Howdy. Really excited for this case. It's complex, but I think it's going to be really fun for you guys. So my job, as Danielle described it to me, was to go through kind of the nuts and bolts of this so we all come out knowing a little bit more than we came in about civil asset forfeiture. So that is my goal today. So the agenda, whoopsies, I have no idea how I did that. The agenda is this. I'll tell you a little bit about the Eighth Amendment. I'm going to tell you what a forfeiture is. We're going to talk about the conspiracy leader exception that was referenced in the video, which is honestly so much cooler than any of the students will get to talk about this year, unfortunately, so I leave it in your capable hands to educate them on that topic. We will talk about some factors of leadership, the Timms test, and that's where we'll leave it off. I left plenty of time for questions. I have very few slides, honestly, so we can just talk about the case instead. So, Eighth Amendment, this is what it says. No excessive bail, no excessive fines, no cruel and unusual punishment. We are only looking at the excessive fines clause in this case. Cruel and unusual punishment is out, and bail is not at issue. There is not much Supreme Court case law on the excessive fines clause. They were mostly silent until the end of the 20th century. I'm talking like 1990s. After that, 1998, the Supreme Court comes out and says, well, what we really mean is proportionality. Measure the value of whatever you're trying to take or the amount of the fine versus the punishment. And if it's proportional, it's probably fine. But at the same time, that didn't incorporate on the states. It only worked in the federal government. So that was the state of law until 2019. In 2019, the Supreme Court incorporated, meaning imposed on the states, the excessive fines clause. And they did that in Timms versus Indiana, or Timms 1, if you will. If you read Timms 1, it's in the case packet. Timms 1 is an in rem forfeiture action, and I will tell you what in rem means in a minute. But note, there is enough written into the case that you can ignore that it's in rem in Timms 1. That should not be a hang-up for this case. Because the Supreme Court made this new law, they said, well, district court, what you need to do is you need to go find some facts because the Supreme Court doesn't find facts. They sent it back to the district court to find some facts relating to their new holding in Timms 1. And so this State v. Timms in the Indiana trial court is Timms 2. Timms 2 is where you get this proportionality test. It's a multi-factor balancing test. These are the three elements. They are not all required. It is an exhaustive list. It's not that you can consider anything else that's just out there. This is all you can consider. But if you get a lot of evidence on the harshness of punishment and not a lot on the claimant's culpability, that's fine. You can still win under Timms 2. So these are factors to consider, and they are not necessary elements of proof. I want to drive that home. In Timms 2, the court walked through really methodically, okay, on the first factor, harshness of punishment, what we're thinking about is ABC. And they go through what I'm calling sub-factors. So these sub-factors are what the kids should be focusing on when they're proving these factors. So they kind of break down further than that. And again, no one factor is dispositive of the entire issue of a gross disproportionality test. No one sub-factor is dispositive of one of the factors of the test. This is a very loosey-goosey standard. This is very new. The law nerd in me says it's very exciting because it's so new, but to your students it may be frustrating because there's not a lot out there. It literally is like 4 years old. So these are, again, not dispositive factors. They are things that should be proven to meet the gross disproportionality test. And like I said, this is fresh, so it's exciting. Okay. So what is a forfeiture? There are really two kinds of forfeiture that I'll talk to you about. The third one's administrative forfeiture, and just forget about it, like I never said that. The first one is an in rem forfeiture. So these are proceedings against property. So if you look up like in rem forfeiture cases, you'll see some cases like the United States of America versus an account at PNC holding $7,367,412.37. And who defends the money? And so you got to go get a a claimant to come in and say, that's my money, and then you defend against that. It's complex. To be frank, we talked about doing it this way, but it just got too complicated. And so we're not doing it that way. There is a criminal forfeiture, in personam forfeiture, which is a proceeding to recoup loss from defendants and give it back to victims in crimes. That's what's happening here. This is an in personam forfeiture against Ash Espinosa, where the state wants his stuff or her stuff. Some crimes trigger automatic forfeiture provisions in different state codes in the federal USC. So things like embezzlement, they do trigger automatic forfeiture provisions. The big difference here, and really the only difference for your purposes, is in personam is against the defendant. The defendant still has rights in this kind of proceeding. There are less protections afforded to a defendant in a civil in rem forfeiture because it's against the property. So for this case, you should treat it as a criminal case. Any of those, if any of your students are prosecutorial maniacs and they love going after, make the streets safe, that kind of stuff, they can still beat that drum. And all your defense attorneys out there can still, fight the little guy and get back against the government. So those are the kinds of feelings you should be having about this. This is against a person, not against property. So, Espinosa wants to avoid forfeiture, obviously. That Camaro is a beaut. Procedurally, this is an evidentiary hearing at sentencing. Espinosa already pled guilty, Diallo pled guilty, and the state went on its merry way to take all their property, everything it could, but now it still needs $18,500. This is a sentencing issue. They've already pled. They've already been adjudicated guilty, and now we're just trying to figure out what is the fine they have to pay to make justice right. The standard of proof for the government in a sentencing issue is preponderance of the evidence. It is not beyond a reasonable doubt. This government must only prove any fact it needs to prove in sentencing, with some exceptions that are not relevant to this case, by preponderance of the evidence, meaning it's more likely than not true. So they want this Camaro, obviously, and Espinosa wants to keep the Camaro. If Espinosa wants to keep the Camaro, Espinosa is going to have to prove that it violates the Eighth Amendment, the excessive fines clause. A constitutional challenge, even in sentencing, if brought by a defendant, is by clear and convincing evidence. That is higher than a preponderance of the evidence. It is less than by beyond a reasonable doubt. Clear and convincing evidence is something like it affirms in the fact finder a strong feeling of veracity or something like that. It's the standard that we use when the government wants to take your kids away from you because you're a bad parent. Or it's the standard that you need when you want to unwind a will because it was done wrong, okay? It's higher than just a preponderance of the evidence, but it's not beyond a reasonable doubt. Again, these are the non-dispositive factors that Espinosa is going to have to prove on Espinosa's Eighth Amendment challenge. And I'll reiterate, these are not, you do not need all three of these by clear and convincing evidence. You need to present these three factors to the judge to convince within the judge's mind by clear and convincing evidence that forfeiture would violate the Eighth Amendment. Okay. Now what's the state doing? If Espinosa has the problem here, then why does the state have to prove anything? Not so long ago, we were in the heyday of restitution for conspiracy offenses. I'm talking big dollars from federal courts. And prosecutors like this, government liked this, because you could get your money from just about anybody. Then, in this case called Honeycutt, which you'll have, Supreme Court came out and said, if we're just dealing with like a drug conspiracy and you get the guy on the corner who nets like 10K, he's not responsible for the cartel's trillions of dollars. You can't get trillions of dollars from your drug dealer on the corner. So they said, this person, this co-conspirator in front of them in Honeycutt, was only responsible for the amount of loss, that's what we call it, in forfeiture the amount of loss that he was responsible for. Then, very quickly after this happened, this district court in Leyva said, yeah, that's fine, but this leader over here, he's responsible for everything, right? So they copped a guy at the top of the conspiracy, and they tagged him with the whole thing. They said, we're going to distinguish Honeycutt because Honeycutt had a low-level street guy, okay? He was actually a guy who was working at a pharmacy who was selling Sudafed. So Honeycutt got a low-level street guy. Leyva got a top-level conspiracy guy, like number one. Level guy. I'm going to tag him with the whole thing. And they did. And there is a current circuit split federally on whether this is right. But for your purposes, forget about it. Tell your kids about it because it's really cool. But you're in a Leyva jurisdiction. So what that means is the state must prove that Espinosa is the conspiracy leader. This is the primary burden. If the state fails to meet their burden that Espinosa is the conspiracy leader by a preponderance of the evidence, stop. Do not pass go. Do not collect $200. You're done. You go home. No Camaro forfeiture. If the state proves that Espinosa is the conspiracy leader, then ordinarily forfeiture, unless Espinosa proves by clear and convincing evidence it would violate the Eighth Amendment. Clear as mud. Great. So factors to consider what makes a leader. And I'm going to level with you guys. I sat in front of my computer and thought, what would I put on if I were the government, what would I put on? I didn't do research for this. This is just what I'm thinking. So first of all, it's fact intensive. It's super fact intensive. Any court case you read, any opinion you read about this conspiracy leader doctrine is going to go through and basically reiterate the entire offense, maybe from the plea deal, maybe from testimony at trial, and go and really parse it out and say, who did what, who said what, who thought this, who started that. So think about like who made the plan, who drove the bus, so to speak. If is someone exerting pressure on the other one to influence the other one to do something. There are natural aspects of leadership. So if this person is always in the front of whatever they're doing, they might just naturally be a leader. It may not be a criminal enterprise, but they're, I don't know, like I don't know, I chair some committee. Okay, he has a natural aspect of leadership. That means maybe he was the guy in charge of the conspiracy. Sophistication is important. Who's more sophisticated here? It makes more sense that we would have an accountant embezzle stuff than a scrapyard owner, because you need a certain level of accounting acumen to make that happen. You could also look at the federal sentencing guidelines. The federal sentencing guidelines are completely free, available online, and they go through some aspects of leadership, some soft aspects of leadership. In recent amendments, they also have little advisory opinion notes underneath them, and they incorporate some of these Leyva type cases in those advisory committee opinions. So while you should not, of course, be relying on things outside of the case materials, so you can't cite those cases, those guidelines, those federal sentencing guidelines, would serve as a good source of maybe blind spots about what makes a leader. So I would encourage you to look there. Okay? Now, I told you I gave you a lot of time. Two or three quick shameless plugs before we go to questions. The first shameless plug is for the annual Miami University Mock Hawk Tournament. It is live online. We are partnering with OCLA again, and so you should all sign up and do that. Yes, it is mockhawk.com, MOCKHAWK.com. If you register a team, I will do my absolute hardest to make sure at least one of your team competes. We don't profit from it. It's a zero-sum game for us. We love doing it. We love having you. So please sign up for that. Get to test out your case. It's in December. I forgot my second shameless plug. So with that, any questions, anything at all, I'm happy to do anything again, explain any questions or any answers to any questions you have. Yes, ma'am.
You just said we're in a Leyva jurisdiction.
Yes.
But it's not a SCOTUS case?
That's correct. You will see that there is a judge's opinion authored by Judge Jamie Armagoss, who read Leyva and says, I'm convinced that's right. We're going to do what Leyva did. So while it's not a SCOTUS case, this judge read it, was persuaded, and said, your trial court judge. Yes, your trial court judge read it, was persuaded it was the correct legal thinking, and said, I'm going to do exactly what Leyva did. Any other questions? There's no way I'm that good. I can't believe that. Yeah. You know what? I'm yours until 3 o'clock or after, so you can process as long as you want. Yes, please.
I'm not an attorney. I mean, are you allowed to go into like emotional things like the cost is too high?
Sure.
That he did this with his son, that it's irreplaceable?
Sure. So this goes into the proportionality. I don't want to zoom all the way back. Yeah, proportionality matters. I mean, that kind of stuff matters, proportionality. So you'll see, I mean, a dollar figure, of course, is important. But in the gross proportionality test, the first factor is harshness of punishment. I mean, are you really going to make me give up my pet project with my kid? You know? I think that fits squarely in there. Yeah. Severity of the offense is the second one. I mean, sure, I embezzled some money, but it's my kid, you know? Yeah, I think that's fair game. At the very least, it's a great argument. Yes, you have another one?
Yeah, who's the moving party in this evidentiary hearing?
That's a great question. So there is not. Oh yeah, I'm sorry. The question was, who's the moving party? The answer is, as you'll read in the judicial order, it's really no one. The court demanded evidence on this issue. I guess how it would come out in actuality is the state would try to get an order and the defense would have moved to stop it, but you're not provided the motions. For all intents and purposes, it's the court wanted it. It is set up that the state goes first, defense goes second, and then state gets rebuttal in closings. Okay? Yes, ma'am.
This might be in the case file, so it's just in the case file.
That's fine.
But you're talking about how, like, you know, this Camaro is a pet project with my kid. My question is, did he use funds that he embezzled towards this Camaro?
Yeah, in the case file. The question was, were there funds used, embezzled funds used to fix up the car? Answers in the case file. Now, I will say, when you read the cases that are also in the case file, you will see that there is an issue on if the property is proceeds of the offense. So if I go out and I steal $1,000 and I go buy something for $1,000, I can't be like, oh, government, don't look here. It's not nothing. They're still going to take it because it's proceeds of the offense. We wrote that out. There's not an argument to skirt around this whole issue just by saying it's proceeds. Anything else? Yes, please. That's okay.
Any way to assert, this might be in the case file,
Uh-huh.
the kid has partial ownership of the Camaro because they did it together and it's his, work also.
Ownership is not in the case file. The potentiality that Oakley owns it is not in the case file. It's not a fact. Yeah. I would go back to Tim's, though. The harshness of the punishment. I mean, you'll see in there it was a pet project. I don't think there was any dispute it was a pet project. Yes.
It was jointly owned by the two cousins.
The junkyard was jointly owned by the two cousins, yes.
The car is not jointly owned by the two cousins.
That is correct. The car is not, yeah. So Diallo's scrap and sale is jointly owned. The car is not jointly owned. The car is wholly owned by Espinosa. Yes.
In terms of like the 300, I can't remember what the value was. The original taken from that 400 embezzled, the original, like, taking it, are we supposed to assume that's 50-50 split between Espinosa and his cousin?
So the question is, this is a mathematical conundrum that me, Danielle, and Ryan went over for a long time. The question was, are we supposed to assume that the 381,500 already taken is evenly split? The judge has artfully danced around this issue. I would say that the question is really this: all the property's gone. No one has anything, for all intents and purposes. Espinosa's family has a house. Okay, great. We're not going to take the house from them. All the property's gone, for all intents and purposes. Don't care where we got it. Don't care where it came from. The car's all that's left. So if the state's going to get $400,000, it's got to come from the car, and the state wants $400,000. Now, where it comes into play is the conspiracy leader exception. So if Espinosa is not the conspiracy leader under Honeycutt, SCOTUS law, Espinosa can only be responsible for $80,000. And they've already got $80,000. Go get the 320 else from Diallo. That's how that argument works. But if Espinosa is the conspiracy leader, he's got a $400,000 bar tab to pay. So the question of division doesn't really come up squarely because of how the conspiracy leader exception works. Does that help?
Yeah. Yeah.
Okay, yeah.
Yes.
I'm hoping when you read the judge's opinion, the judge's opinion, we took a lot of care to make it really clear about what's at issue, and I hope that the judge's opinion would answer any outstanding questions.
I'll rephrase it based on how you explain it here.
Please.
Make sure I have it right. Basically, we can assume everybody's been taking 50-50 right now. The leader's going to determine who's giving you that last percentage.
Yeah, so the restated question back was, assume everyone's taking 50-50, leader gets the rest. Not really. Because if you're Espinosa, you want to say, you've got 100% of mine. You got all 80. You took everything I have except for my family's house. So the percentage division doesn't matter. And frankly, the state isn't going to look at it like a percentage. They're going to, where's my 400, right? So the percent, I wouldn't get hung up on it. There's really, in the law, in the case law you're provided, there's,
I guess in terms of that percentage, it's taken equally from both guys so far, is what we should assume. It's whoever's giving that last percentage to get to the 400 total. It's not like
in a way. It's not a 50-50 split. If you're Espinosa, if you're the state, you don't care, so you never assign numbers to it. If you're Espinosa, you say, well, hold on, you're at like a 3,000% right now of what right? So you're never going to get the parties to agree on what the split is in this circumstance.
Are you saying Espinosa is responsible for the 80,000 per trillion?
Espinosa is responsible for the 80,000 per trillion.
And nothing else?
That's the question. That's the question. So Espinosa is certainly responsible for the 80,000 per trillion. Go back to Honeycutt. That's the low-level pseudo dealer in the pharmacy, 80,000. Easy. The state wants 400,000 because, let me back up. That's a great question. The question is, why do they want 400,000? When you have the conspiracy at Diallo Scrap and Sale, they funnel 80,000 in, they launder 80,000 through Diallo Scrap and Sale. The video mentioned that there was another 320,000 that came from somewhere else. The case kind of explains where the somewhere else came from. When the state looks at that set of facts, because that $320,000 didn't go to the IRS, there's no tax on it, they want $400,000, 80 plus 320. Okay? So from Espinosa's perspective, I've paid $80,000. You have, if I didn't pay it, you have $80,000. You liquidated my junkyard, which I own a certain percentage of. You took all the bank accounts I have. You left my family with literally just a home. You have my $80,000. And the state says, but you're in charge of the whole thing. So we need 18.5 more. And their hand is kind of forced because now Diallo has Zippo. Diallo doesn't have a house. He's Zippo. He's in incarceration. So they have to go for the Camaro.
He's not arguing that the taking of his interest in the junkyard is also excessive. He's only responsible for 80,000.
He's not arguing that. Maybe he waived it. Are there any other questions that we can talk about? This is the best part of the whole thing. Just chatting. Oh, yes.
So, if there's going to be a leader, does that mean one person, or can it be two people be the leaders?
There is case law that says that you could have two leaders. It's in the case packet.
Can I ask a question?
Absolutely, you can.
What I'm most concerned with is who is the leader, and was that made clear in the criminal trial?
So that's a great question. There was no trial. So this case's procedural history is this. They get indicted and arrested, both of them. There's a search warrant beforehand. They get indicted and arrested. There's a pretrial phase. Diallo takes a plea, and then Espinosa takes a plea. And so there is, and you will see there's really not a statement of facts in the plea agreement like there normally. I mean, no one's really talked about this as far as the trial court goes. So when I say what are the you know, when I say that opinions on this kind of recite the facts of the crime, I am anticipating many prosecution teams will kind of go out and prove a crime happened, even though they're admitting a crime happened, kind of go through the facts of what happened. To prove the leadership, you'll have to do that. So that's what you're relying on to get to the who is the leader. And again, that is the first burden. If the state does not meet that burden, you're done. $80,000 already recouped. You can't get a dime more from Espinosa. Go find somewhere else. Yes. That is correct. Only you.
Test then would go not only between the state and the 18.5 they still want, but it would also go between the two co-conspirators in terms of what was fair and their contributions?
So the question is that the gross disproportionality test works for both co-conspirators. Espinosa is the only person arguing it was an Eighth Amendment issue to forfeit the Camaro. His co-conspirator is actually a witness for the prosecution.
I don't know materials we have, we understand that there's going to be some varying opinions about the value.
Oh yes, there will be many varying opinions.
The Camaros were 50 grand and they're only looking for 18.5. There's a proportionality basis versus the original were at 16 and they're looking
Or zero.
for 0. It ain't worth 0.
Well, I'm not a car nut, but maybe.
Even if something's hard, it's hard.
Yeah, that's right. Yeah. Yes.
I'm just curious, how much did Espinosa pay for the Camaro when he bought it?
That is in the case. That is a yes. That is a fact I will hear evidence on when I judge these trials. Yes. Either of you.
Is it clear and convincing evidence or preponderance?
It is both. And let me hit this one more. I wanted to hit this again before I close down. Yeah, please go ahead.
Where's the 18.5 coming from?
So the government has already recouped loss in the amount of 381.5. They liquidated the junkyard. They took a bunch of assets. Clearly, in the judge's order, clearly stated. So the question on the burden is this, and I did want to restate this because this is at least in my experience, the first time OCLRE has allowed me to give you two burdens at once. So this is it. First, the state must prove, MUST, must prove that Espinosa was the conspiracy leader. The burden of proof is by a preponderance of the evidence. It is more likely than not that Espinosa was the conspiracy leader. And those are your factors, just general facts about who's in charge of this thing. If they meet that burden, the defense could say, no, and try to dissuade the judge and say, no, I wasn't the leader. And if the judge says, no, you weren't the leader, done. Defense wins. To move on, the state must prove that Espinosa was the conspiracy leader. And despite attempts to rebut that evidence by the defense, the state must maintain that Espinosa was the conspiracy leader. If the state meets that burden, then Espinosa's burden kicks in. And Espinosa must prove by clear and convincing evidence that forfeiture of the Camaro would violate Espinosa's Eighth Amendment right against excessive fines, using the gross disproportionality test, the non-dispositive factors, helped by the non-dispositive sub-factors, a very mushy-gushy legal test that nobody likes, but it's very fun because it's brand new. Yes.
I'm assuming that the witness options will preclude the defense from not arguing what's essentially an affirmative defense.
I will say this. A defendant would win if they merely disprove leadership. You will have the case file and you can decide. Did you have one? Yeah.
Kind of touch back a little bit on, anyways, not necessarily looking for the accounts, but we have a general idea of all the things that we see.
Yeah.
Okay, so like, for me, it would be the connection for how is this car in relation to everything else that was seized?
value to value of, yeah. You will have a breakdown of the value of the junkyard, which you saw was liquidated. You'll have a breakdown of Diallo's, I'll say contribution, and then a breakdown of Espinosa's contribution, and the reasons why, topically, the reasons why Espinosa couldn't give more. Yes?
If there's regards what the cars were, 85, 65, the government only needs 18.5, they sell the vehicle and does the defendant get the balance?
Where the balance goes isn't at issue yet.
If I'm looking at excessive fine and there he's gonna get the balance
Sure.
back and only actually put out 18.5, that's my question.
And I think that is ripe for argument. I would say right now in front of this judge, the question of where is the excess going, or who is responsible for the outstanding amount. If it sells for 5, right? Who's responsible for 13? Not before the court right now, but ripe for argument, I think.
So we could argue that if he's gonna get the balance, the net proceeds after the 18.5 is paid for.
It's not. I'll be clear. It's not in there. So I mean, if you could make the argument and see what judges think, but that is not a. If you could maybe hamstring it into one of the gross disproportionality factors.
It's not
Sure.
it's not the case level we have what happens with
No.
exceeds more than 15.
No, because that's not the motion.
Still mock trial rules as well in terms of any outside research or anything that's not included in the case materials. Just read this. Again, it's always good.
Yes. Please do not do outside research, even though I really hope you instruct your students and teach them about the conspiracy leader exception, because it is a fascinating thing that these district courts are doing. Yes, ma'am. Well, look at that. There are facts in the case that may prove different, but I again look forward to hearing your evidence. There you go. It's yes, you will see a lot of different numbers. Yes, sir.
You were moving, well, my brain wasn't comprehending as fast. I think you did a great job. Can you go back to the multi-factor balancing test?
Yeah, on Tim's.
Yes.
Yes,
And explain that. Can you just,
I absolutely can. It wasn't because your brain wasn't working. It's because I was just trying to get to questions.
not getting older and that writing is
Oh, yeah. So there are 3 factors. The first factor is the harshness of punishment. The second factor is the severity of the offenses. And third is the claimant's culpability. Those are the 3 main factors that this court is going to look at to determine whether this forfeiture violates the 8th Amendment.
that's Tim's too.
That is Tim's 2. That's correct. Because the Supreme Court said, yeah, you got to abide by the 8th Amendment because we incorporate it. Go figure out how to do that at the trial court. And this is what they came up with. And again, just to there are these additional sub factors, and this is all in the case law that you're provided. So it's Tim's 2 is very thorough. There are sub factors. In factor 1, we consider bullet, and it goes through for every single factor. So it's very, very clear. Yes.
So if you look out Tim's Indiana, is it going to tell you, or should you just look up Tim's too?
It's going to be in the case packet. You won't have to look anything up. Yeah. The very public secret about Tim's is, of course, it went back up on appeal and it's kind of percolating. So the 2 that we've given you, that's the universe. I wouldn't go Googling nothing about Tim's. Well, it is very interesting. It is very, very interesting.
Do that, Bart.
So was Tim's 2 in 2019?
Tim's 2 was later than 2019. I don't have the year offhand.
Okay,
It-
so 2019 was Tim's 1.
That's correct. Yeah. I think it might have even been, I think it was 2020, maybe even 2021. It was later because it had to go back and, yeah. Tim's case, was that? So the question that I rudely eavesdropped over here is what was Tim's about? Tim's, remember, was an in rem forfeiture proceeding, And this had to do with a vehicle that was purchased with proceeds of drug deals, if memory serves. So recall, you're not dealing with proceeds because we've sipped it out. You're not dealing with in rem forfeiture. This is in personam criminal. We're saying, forget all of that. Forget these distinguishing facts. This is such a new area of law that this is the best we have. So just go with Tim's. Yes.
Are the plea deals they signed in the case file?
Yes, they are. They were written by, not me, a federal prosecutor. They're very good. Yes. Yes.
So what should we expect now that there are actually like two tests that we're working with in terms of how this moves about during a trial? Because it's not like we determine one and then go back and then determine two,
Right.
right?
Right.
So what should we expect for those of us who it's the first time we've ever, well, you said OCL hasn't like used before.
Not in my memory.
What are some things that we should anticipate that we kind of have to?
Yeah. So just so everybody here, the question is what to anticipate procedurally in trial. Can't go back, can't do it again. What happens when the burden shifts? I can only give you tips. It's going to proceed like any other OCLRE case. It's going to be, okay, state, stand up, give your opening, defense, give your opening, and you're going to go two witnesses, direct cross, whatever. Closing, state, defense, rebuttal, just like normal. The trick is going to be how you decide, and I really mean how you decide, because it is a very fluid. I mean, the state has to do what they have to do, right? I view the defense as a little more fluid. It depends on how you want to present your case. You've got a lot of options, and I'm not going to list them out here, but I've got at least 4 or 5 in my head that I could do, and so y'all are smart coaches, and your legal advisors are great too. And if your legal advisors in the room, other than Missy, then I'm sure you're real smart. But you can figure this out, okay? It's gonna be, at most, you'll have 2 burdens at once. And you're gonna have to describe that, whose burden is what's the standard of proof, and what am I looking for? The benefit, well, the upshot, maybe not a benefit, the upshot is both of these burdens, the things that prove them, are very gushy. What is a leader on one hand versus this gross disproportionality test, which has like 12 sub-factors supporting 3 non-dispositive, very mushy factors. So I like high school cases that are very fact-based, because then the witnesses matter, impeachments matter, that kind of contradictions matter, that kind of stuff. So you get the students working in the trial to prove, disprove stuff and take stuff head on, like improv, right? And so hopefully these cases as you work through them, or these burdens as you work through them, you see this. It's very fluid on how you prove it. That's my hope.
So the defense is going to have to decide based on what happens. Prosecution, where they.
You might think you have to. If you present this to your kids and you decide the best way to do it is to be completely reactive, then okay, that's a choice. Or you could just say, we're going to do this, and then you go do that. I mean, the benefit of both sides having a burden is the defense can just get up there and say, this is our burden, and we proved it. And it may have gone understated, but if the defense proves an 8th Amendment violation, you also win, regardless of whether they prove conspiracy to lead or not. If the state gets up there and just like flubs everything, and they never prove it, well, you're going to win. But if you get up there and also prove 8th Amendment, you also win. So you could lock it in. There's a couple ways to do it. Yeah. Yes.
I'm sure you guys have already thought about this on the case committee.
We might not have.
Is there a preclusion for the defense to just concede that he is a leader?
You can.
Object to everything, is that in the case, or if not, I'm gonna write an erotic question.
You can write your question.
Okay.
You can read the case. I don't want to give you too much strategy.
Well, yeah, I was more asking, did the case committee think about that issue?
I considered it.
The defense.
Yeah, I considered it. Mm-hmm. Anybody else? This is by far the most complicated case they've ever done, so this is okay. I'm going to give you the burden one more time, because this is the most important thing. The burden starts with the state.
Hey, this is important.
The burden starts with the state. They must prove by preponderance of the evidence that Ash Espinosa is the conspiracy leader. They may do that by demonstrating facts that would support that he is a leader. Very mushy. They must prove that that is more likely than not true by a preponderance of the evidence. If successful, in order to prevail, Espinosa must prove that forfeiture of the Camaro constitutes a violation of the Eighth Amendment by proving, by clear and convincing evidence, something more than preponderance but less than beyond a reasonable doubt, that the gross disproportionality test is satisfied by presenting the non-dispositive Tim's two factors. That's how I would say it, in an objective sense. Your advocates may say that differently. Okay. I am happy to take further questions, but I'm sensing that there are none. So I thank you very much. I truly hope you have fun and it's not overwhelming. I'm very excited to judge these rounds. I hope you get your students excited. I hope you're excited. And I will see you in competition. Okay.